Good afternoon. I welcome you to our annual Irving Tragen lecture on comparative law. The lecture is named for our graduate, Irving Tragen, whose generosity has funded this annual lecture in the Irving G. and Eleanor D. Tragen Chair in Comparative Law, which is held by Professor Katerina Linos. Irving, who graduated from Berkeley Law in the class of 1945, was a distinguished diplomat with 55 years service in inter-American affairs. He was a Foreign Service officer for 35 years. His assignments included senior diplomatic and development posts in Latin America and the Caribbean. In 1980, Irving joined the Organization of American States Economic Development Program, which tackled debt and foreign trade crises, border area infrastructure projects, and manpower development initiatives. He has written a wonderful autobiography titled Two Lifetimes as One, about the experience that he and his wife, Eleanor L. Dodson, had in their work across the world. A California native, Irving received both his bachelor's and law degrees from UC Berkeley, along the way meeting his beloved wife at the International House here on campus. From his years of service in underdeveloped nations, Irving is resolute in his belief that, quote, education is the key to advancement of any population. He said, "My heart is with the California public university system. I owe my whole career to UC Berkeley, and I'd rather support the University of California than any other single institution." Irving joins us for this lecture today, and I should also mention he'll turn 100 years old on May 18th. And we could not have a more distinguished professor to deliver this year's Tragen lecture, Harvard professor Intisar Rabb. Professor Rabb is a professor of history, a professor of law, and the faculty director of the program in Islamic law at Harvard Law School. She's held many other appointments. She was the Susan S. and Kenneth L. Wallach Professor at the Radcliffe Institute for Advanced Study. She was an associate professor at New York University's Department of Middle East and Islamic Studies, as well as NYU Law School, and an assistant professor at Boston College Law School. She's published on Islamic law in historical and modern contexts, including the monograph Doubt in Islamic Law, published by Cambridge University Press in 2015, and the edited volumes Justice in Leadership in Early Islamic Courts, which was published by Harvard University Press in 2017, book called Law and Tradition and Classic Islamic Thought, published by Palgrave Press in 2013, and countless articles on Islamic constitutionalism, Islamic canons, and an early history of the Quran text. She received a bachelor's degree from Georgetown University, a JD from Yale Law School, and a master's and a PhD from Princeton University. She's conducted research in Egypt, Iran, Syria, and elsewhere. So I'm delighted to introduce you to our 2022 Tragen lecturer, Professor Intisar Rabb.
Thank you so much, Dean Chemerinsky, for the warm welcome and introduction, and to Irving Tragen for endowing and making this lecture possible. It means a great deal to be able to think about and exchange insights of comparative law in spaces like this, and where it's really crucial to understanding the laws of our interconnected world. And so I also want to add to the celebration here and wish you a happy birthday. Erwin, or Dean Chemerinsky, another thank you for inviting me to give this lecture this year. I had the pleasure of actually learning the law of con law from the video images of you when I was studying for the bar in New Haven after graduating from the school there that's been affectionately called Liberal Arts Law School. Then I had the pleasure of actually meeting you at UC Irvine when you were dean there, and had actually invited me to give a lecture on Islamic law for the inaugural Malas chair. And I so loved the visit and dinner and all the conversation that occurred even outside of the lecture, which I found very generative. And now I'm back to video screens for now, except this time I'm the one mostly doing the talking from the original video screen days, even as I hope to listen and engage with you all during the question and answer period that I hope to leave time for following the talk. I also want to thank Professor Katerina Linos, who hosts a wonderful new podcast, Borderlines, about global problems in a world fragmented by national borders. And I look forward to joining her pod to continue today's conversation in case anyone's interested. And thanks to Jennifer Boyden and to Whitney, who helped arrange the flyer and logistics and will be doing the moderation today. And finally, thank you to the Berkeley Law and History students who reached out and are in attendance here and who I have scheduled time to meet with after this lecture. And any students who are here and who'd like to join, you're all welcome to join. And we can find a way to get you the Zoom link for that. I hope everyone can see my screen. Today I'll be talking about METACANONS, comparative textualism at the US Supreme Court and in Islamic law. So by way of background, legal canons have really made a comeback on the US Supreme Court and in the Islamic world. Legal canons are interpretive principles of law that judges use all the time to interpret. Some of them, to give a couple of examples, are like the rule of lenity. When in doubt about the law's ambit, interpret criminal statutes narrowly, that is, in favor of the defendant. Or the ordinary meaning canon. Read statutory provisions according to their ordinary meaning when interpreting ambiguous texts. And there are often dueling canons that need clear rules for whether and when to use them, which at present are not available, those clear rules. So where does comparative law or Islamic law fit in? It turns out that American and Islamic legal systems share many of the same legal canons, especially textualist ones and some substantive ones. So for example, there is an Islamic rule of lenity, qa'idat al-shubha, that says when in doubt, avoid criminal punishments. And there is an Islamic ordinary meaning canon, qa'idat al-haqiqa, that says virtually the same thing with virtually identical wording as the American legal canon. When resolving ambiguities, choose the ordinary or plain meaning unless the text indicates otherwise. So this idea that there are shared similar legal canons, this is so despite the radically different institutional structures, origins, and commitments of each system historically and today. And I propose that probing each system individually, then juxtaposing the two, can uncover shared meta features of legal canons in these two very different, perhaps maximally different legal systems. And that can provide guidance on how and why judges should apply them. I call this comparative approach to legal canons and the shared meta features of legal canons that it reveals, the study of metacanons. Now, another point worth mentioning is the conventional view of comparative law and whether Islamic law can easily fit in it. To be sure, a comparison between American law at the Supreme Court and Islamic law historically seems too improbable, too difficult, too meaningless, perhaps, to be worth the trouble. It doesn't fit neatly into the most popular comparative law approaches. I can name three: There's better law functionalism, where you compare laws to select the better approach to solving a legal problem. Legal family grouping, where you identify and compare similar structures. Or analytic debate, where you assess and unpack conceptual differences within the cultural context of a particular legal system, or through tracing, borrowings, and transplants. But after overcoming hurdles of improbability and difficulty, requiring in some cases to learn a few languages, gain expertise in each legal system, become a lawyer and historian, but it doesn't always have to require that. It seems clear to me, and I hope to demonstrate to you, that there is a point or two to the comparison, and it's exciting and meaningful. That is, the existence, continued use, and recent resurgence of legal canons in both systems, American and Islamic, suggests that there are common features of their shared canons, metacanons, that play out in almost every interpretation. And the existence of metacanons demands a more coherent response, I argue, from scholars and from judges in matters of interpretation. So of course, that raises a question here. Why care about metacanons for US Supreme Court cases? So my basic claim, my basic argument is twofold, on which I then build a conclusion. First, I argue that courts demonstrably have abandoned the notion of court, Congress, institutional dialogue in modern applications of legal canons, in ways that resonate closely with the differing structures of Islamic law and Muslim jurists in older systems, a notion they had initially adopted, but recognized as fictive long ago. There is no dialogue between judges or jurists as interpreters and a divine legislator in that system. Metacanons can help make clear why this matters. And second, I argue that the facts of similar legal canons in these disparate legal systems, both of them lacking in institutional dialogue, meaningfully informs the debates about both the means and the ends of statutory interpretation. These facts call for resolution, I propose, and for new approaches to the judicial use of legal canons, with an eye on what we can call metacanonical inquiries. And in the end, I argue something fairly provocative. That is that canons have become, in our era of declining or fictitious institutional dialogue between courts and Congress, canons have become interpretive tools by judges and for judges. Judges who have dispensed with the myth of dialogue should seek more coherent use of canons to bolster rule of law values, or judges should reopen the channels of dialogue and deploy the canons to mediate the ongoing cases and controversies about changing values in light of American constitutional norms and congressional preferences. This latter point, I'm suggesting that judges face this twofold choice. The second choice is a path that Islamic law judges did not and could not pursue given the differing structure, non-constitutional system and differing values. But thrown into relief by metacanons, this path offers a unique prospect for advancing American democracy. So that's the talk in a nutshell. And if that were clear, we could end and you know, I could open up for Q&A here, but you'll no doubt want examples to give you a richer sense of the nut inside that shell. So I'd like to unpack it beginning with the Facebook case from last year at the Supreme Court. So I'll spend some time discussing that case along with some Islamic law analogs in the first part of the talk. And in the second part of the talk, move to discussing what I call the canons comeback, the fact that there's been a resurgence of canons, except without the institutional dialogue in the American legal system that first justified the use of canons. And finally, I'll conclude with a provocation about metacanons, that they shed light and may lead to this choice that I described just a moment ago. So Facebook. Now, even discussing the Facebook versus Duguid case of 2021 is a bit meta in a colloquial sense, because Facebook has itself become meta, and thus relevant in a different way to the idea of metacanons that this talk explores. The company's recent case before the Supreme Court, in fact, calls up major issues that arise in ways relevant to my proposed comparative law sense of metacanons. So in the case last year, the Supreme Court deployed a little known legal canon to side with the company formerly known as Facebook in a lawsuit over unsolicited text messages that were sent to Mr. Noah Duguid's mobile phone. Mr. Duguid sued the social media behemoth on behalf of a putative class of aggrieved text recipients nationwide. Facebook had sent several text messages alerting him that someone had attempted to access the Facebook account associated with his phone number from an unknown browser. The only problem was he had never opened a Facebook account or given the company his number. For the company to send such texts, Mr. Duguid argued, they were really violating the Telephone Consumer Protection Act, the TCPA of 1991. And that act imposes a federal ban on so-called robocalls by, among other things, restricting companies from making calls with an automatic telephone dialing system, or an auto dialer for short. That act defines an auto dialer as equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. So what was Facebook, Mr. Duguid asked, about the text he received, if not a robo-texting auto dialer within the meaning of this statute? At oral argument, the parties raised longstanding questions about the relationship between Congress and the court in statutory interpretation. Wouldn't Congress have meant to account for changes in technology? And wouldn't they have passed the statute to protect individual privacy? But the court explicitly considered and then ignored issues of dialogue or they considered it in the oral arguments, ignored it in the actual opinion. Instead, in a written opinion in the written opinion for a unanimous court that Justice Sotomayor authored, there was a concurrence, which I'll get to. She distinguished between a set of dueling canons. One was the series qualifier canon. The series qualifier canon says, construe a qualifying clause following a series to modify all the antecedents that preceded. Meaning you have a clause that comes at the end of a sentence that applies to everything that came before it. Using that canon, you would conclude that the TCPA's qualifying clause applies both to its capacity to store a telephone number and to produce a telephone number. Both antecedents are modified by the qualifier. And Facebook would further argue, regardless, the company didn't use technology involving a random or sequential number generator. They didn't store or produce the numbers that they dialed. Now, on the other side, you had Mr. Duguid, and he was represented, by the way, by Brian Garner, who is the co-author of the book Reading Law, the treatise really on legal canons that the Supreme Court now frequently cites in its statutory interpretation cases. The late Justice Scalia was his co-author. So Mr. Duguid, and through his counsel, Brian Gardner, argued that the last antecedent canon applied, which says, well, really, you should just construe a qualifying clause following a series to modify only the last antecedent. It doesn't apply to everything that came before it. It only applies to the very last thing before the final clause. That was the more ordinary or natural reading, the way language typically works. That's what the book Reading Law argues. And if you read it in that way, to be an autodialer, a company must only produce numbers, not store and produce, in order to be liable under the statute. This was a case of dueling canons. It was the series qualifier canon against the last antecedent canon. And they're two faces of the same entity, but in this case, the Supreme Court applied the series qualifier canon and Facebook wins. Now, Justice Alito voted with the majority, but he had some concerns that I think are directly relevant to a metacanonical inquiry. He concurred then so that he could comment on the function, authority, and prospects of ordering legal canons, in part perhaps with the use of data science tools. To those ends, he cautioned against viewing canons as inflexible rules, as did the majority when it referred to its favored canon, the series qualifier canon, as a rule of grammar. And he cautioned against making evidence-free assertions about their basis, such as when the majority declared that the series qualifier canon generally reflects the most natural reading of a sentence. How do we know? And he cautioned against invoking canons only partially and without all their caveats and limitations, knowing as through reading the book on the subject Reading Law that there is always a canon, and not necessarily just a counter canon to cancel it, but there are always caveats, limitations, and a hierarchy of canons that apply, even though scholars and judges have not yet worked that out. So for him, canons are presumptions, not rules. They're meant to reflect ordinary grammatical usage. And I provide this quote here because I think it's worth looking at the language for the metacanonical inquiry that it relates to. The strength and validity of an interpretive canon is an empirical question, he says. And perhaps someday it will be possible to evaluate these canons by conducting what is called a corpus linguistics analysis. That is, an analysis of how particular combinations of words are used in a vast database of English prose. If the series qualifier canon were analyzed in this way, I suspect we would find that series qualifiers sometimes modify all the nouns and verbs in a list, but sometimes they modify just the last noun or verb, i.e. the last antecedent canon. It would be interesting to see if the percentage of sentences in the first category is high enough to justify the canon. So his are questions really about metacanons, and all of them are notably distinct from the notion of congressional dialogue, which I'll unpack a bit more. So rather than ask, how does Congress expect judges to interpret its statutes? He encourages the court to more precisely consider the authoritativeness and empirical function of certain canons by looking more comprehensively and systematically at how they were applied over time to detect what is the natural use of language empirically. The more data to aid in what he clearly sees as that judicial task separate from congressional dialogue, the better. So he didn't mean this, but I want to take that notion even farther and ask, what if we expanded his scope of comparison to comparative use of rules of language in order to appraise what is natural use and to justify the canons. So this is what I'm calling the metacanonical inquiry and the promise that I think metacanons have to add. So how about the Islamic law side of things? Islamic law as a legal system historically is much less case-based than treatise-based. And analysis typically proceeds on the basis of legal treatises that elucidate rules, often but not always related to Islam's two foundational texts, with a heavy dose of canons in the process of interpretation. So what are those texts? Those form the basic building blocks of Islamic law. The first is the Quran, Muslim scripture, and the second is Sunnah. Collections of thousands of reports called hadith, which are statements of varying degrees of authenticity by the time they're collected, some 250 years to 300 years after the Prophet's death. They're statements that are attributed to the Prophet Muhammad and to early founders or founding authorities that, if found to be authentic and to fit in with the broader the broader ambit of the law, have the force of law. So Islamic law also features multiple schools of interpretation that take these basic building blocks and construct or architect separate spheres or approaches to interpretation. And those are popularly known as the schools of law or madhabs. 4 Sunni schools, 4 Shi'i schools. And each of them takes a different approach to legal canons. Which canon should be adopted as default rules and why? So let's take 2 examples of disagreement amongst these schools as an example. The majority of Islamic law judges and jurists, so that is 3 of the 4 Sunni schools, Shafi'is, Malikis, Hanbalis, as well as the mainstream Imami Shi'i school, they apply the series qualifier canon, as did Justice Sotomayor in the Facebook case, unless there is some contextual indicator restricting the qualifier to the last term in the list, i.e. dictating that the last antecedent canon should apply. So I want to take 2 examples from criminal law. This is a verse, Quran, Surah or chapter 25, verses 68 to 70, that says, "As for those who refrain from taking a life that God has made inviolable, except as legally authorized, nor commit illegal sex acts, anyone who does so commits a sin worthy of punishment, except," and this is the proviso, "except for those who repent, confirm their faith, and perform righteous deeds. For them, God will replace their evil deeds with good deeds, for God is all forgiving, most merciful." So the series qualifier approach to this canon, meaning the majority of Muslim jurists, take this to mean that there is no punishment for an offender of this list of items before this except proviso, provided a person shows remorse, and repents in the ways outlined here. These jurists see no contextual or textual indicator that the mercy or repentance is limited to any one of the acts. To the contrary, the indicator they see is anyone who does so. Anyone who does so indicates relevance of the full list, the entire series. By contrast, there are some jurists, a minority of jurists, that reject the series qualifier canon as the default, and they adopt the last antecedent canon as the default rule. That minority is the Hanafi jurists of the Sunni branch of the Islamic world. And they say, take the last antecedent canon as the default rule, unless there's some contextual indicator that a judge should depart from that meaning. And they're making basically a similar argument that that's the more natural reading of text. And they use as an example, Quran 4:92, that says, a believer may not kill another believer unless by error. And whoever kills a believer by error must free a believing captive from bondage and pay compensation to the victim's family, unless, and this is the proviso, unless they forgo it as an act of charity. Now here, the general agreement in the Hanafi position is that the final proviso, unless they forgo payment as an act of charity, applies only to the last antecedent. That is, compensation to the victim's family can be forgiven rather than compensation or any kind of retribution or punishment forgiven if one were to apply that proviso to all of the terms that preceded it. So in other words, the pardon of a victim's family can absolve someone convicted of homicide of the need to pay them compensation, but it will not absolve that person of the duty to take other compensatory measures, namely, in this case, freeing a captive from bondage and any other punishment that the state might inflict. So for this minority taking this position, there's nothing indicating that the last proviso should extend to cover both items in the list. And they use the example, in fact, to show that the more natural reading, the more ordinary reading, if one is looking for a default rule, is the last antecedent canon. But there's dispute about that. And there's a smaller, even smaller minority of both Sunni and Shi'i jurists, individual jurists, who say that, well, it's not really clear. Maybe they had in mind the idea that, like Justice Alito, you'd really have to do a comprehensive survey of the way language works. What's the percentage of time that series qualifying canon or series qualifiers apply rather than last antecedents apply in the natural order of things in interpreting language generally. But there was no such capacity to do that sort of thing, to come up with a percentage of what's more ordinary. And so they said, well, maybe judges should just practice interpretive avoidance when the text itself doesn't give clues about which of the two dueling canons should apply as the default rule. But that's impractical. The supermajority of jurists roundly rejected this idea. In a system where there is no legislator to update the law, the idea behind Islamic law is that there was one divine legislator with a capital L, God, who legislated once, and then there ceased to be dialogue after the death of Prophet Muhammad. So you have a system where there's no legislator to update the law. That would grind matters of law to a halt. So instead, they advocated for one default rule or another within their individual schools, their approaches to interpretation. And they implicitly acknowledge that disagreement about which canon applies across the schools created space for jurists, created both space and reason for jurists to make arguments in favor of one canon over another to take precedence as a default rule. Then each canon documented or codified the canons in canons collections starting in the 14th century giving reasons as to why one default rule should take precedence over another outside of the context of actually applying it to cases. All right, so we have the landscape then of the two sides, American and Islamic, as far as their approaches to legal canons and the examples of the dueling canons that I gave. And now I want to talk about, well, what do these cases show with respect to the canons comeback, but a decline in the courts Congress dialogue in the American context, primarily. So first of all, there is a divergence between theory and practice. In fact, it's a long-standing divergence between conventional theories of statutory interpretation and judicial practice. So the conventional theories, that of scholars, of law professors like myself and colleagues and many of you, it's said before that, well, legal canons are interpretive tools that are sort of relevant curiosities, but maybe not really relevant. And they were long ago maligned as vacuous. So here in American law, Carl Llewellyn excoriated the use of legal canons to interpret statutes as inconsistent and incoherent well over half a century ago. And among Islamic law experts, there was a heavy use of these legal canons early on, beginning in 7th century Arabia. You had scholars of Islamic law begin to collect and organize these canons. In 14th century Egypt and Syria under the Mamluks. And the Ottoman Code famously used some of those canons to reform and modernize its law in the mid-20th century. But after the fall of the empire and the rise of codification of the issuance of statutes from legislatures following colonialism and the rise of the nation state in the Middle East and elsewhere, canons, a scholarly record would show, kind of no longer seemed relevant to Muslim societies. So that's the scholarly view. They're curiosities that aren't really relevant, and even if they are, maybe they are inconsistent and incoherent. And then there's the judicial practice in both systems. Most judges, nevertheless, have continued to use canons, both textualists and non-textualists alike. I'm not the first person to observe this. Dick Posner observed it long ago for American law, and other scholars noticed the same thing. And I've written on this in Islamic law, as have some others for both medieval and modern judicial practice, that the legal canons have been in continuous use amongst judges and other jurists. So the recent canons comeback, or their increased use in both arenas, both in American law and in Islamic law, and both in the courtroom and in the classroom, has recently expanded. There's a canons comeback in the courtrooms, and there's a canons comeback in the classrooms. So in the courtroom, I think I can comfortably say that virtually every statutory interpretation case at the Supreme Court of late features some degree of canons, dueling canons perhaps, oftentimes facing off on the meaning or application of ambiguous laws. Anita Krishnakumar has done wide-ranging studies, actually one called Dueling Canons, another called the Whole Code Act, that does an empirical study of some 530 statutory interpretation cases in the Roberts Court first 12 years. And it reveals that almost every case features these canons. The Facebook case is just one example. We can name any number of prominent cases that do the same. To just give a couple of other examples, there's Yates versus United States, a 2015 case that asks whether fish are tangible objects, and whether the rule of lenity, for example, applied. Bostock versus Clayton County, Steer asking whether a ban on discrimination on the basis of sex extends to sexual orientation, and where you see a face-off between the ordinary meaning canon in Justice Gorsuch's majority and the rule against superfluities in Justice Kavanaugh's dissent. Or Bond versus the US, a 2014 case that asks whether a jilted wife who poisons her adulterous neighbor has violated laws banning chemical weapons. And again, asking about ordinary meaning and the rule of lenity. So canons are everywhere in the courts. They're also in the classrooms. Law professors have simultaneously started to re-examine the role of canons, noticing how much they're being used. And leading law schools now feature and sometimes require courses in legislation and statutory interpretation, each of which comes with a heavy dose of legal canons. So I hope that this is not news to many of you. And the law professors teaching these cases are often commenting extensively and devising theories meant to better understand the modern use of legal canons, help guide it, oftentimes supported with amici briefs in the court. So this comeback in both the courtroom and the classroom, I think, helped close one gap between theory and practice. That is the earlier scholarly theory about the relevance of legal canons to interpretation and the judicial practice of the canons that underscored them as relevant, but it didn't resolve other core questions, and in fact may have created some new ones. Those new questions relate to the absence or decline of institutional dialogue. So now, there's a divergence between the new canons comeback and the theory that grounded them, which originally had to do with court-Congress dialogue in American law. So let me put it this way. Arguably, the strongest justification for many legal canons in American law is that they operate on the backdrop of this court-congressional dialogue. Take the rule of lenity, for example. It's a clear statement canon, which is a whole category of canons, that it requires a clear statement of law from Congress before criminalizing behavior. And construing a statute narrowly in a criminal context, unless it's really, really clear, offers a prompt to Congress to clarify its statement of law, thereby allowing the court to say that it is deferring to legislative supremacy and forcing democratic accountability. Likewise, whole code canons, like the rule against superfluities of the type that I just talked about, that Justice Kavanaugh used in his dissent to Bostock versus Clayton County. And there he argued that on the basis of sex should have been construed narrowly, lest it render other statutes that specifically say sexual orientation meaningless. These type of canons suppose that Congress legislates against the backdrop of the whole federal code and precedents from the court. And it does so, therefore, in dialogue with previous Congresses and with the court. And other textual canons, like the ones at issue in Facebook, like the last antecedent canon, purportedly reflect ordinary usage in complex statutes, and it's usage that puts the courts and Congress on the same page about how legislation is likely to be interpreted. thereby also presuming some conversation between Congress and the courts and respecting legislative supremacy in the process. So then the old and most robust justification for the canons is this idea that courts and Congress are in dialogue with one another through legislation and interpretation. There are ways each can be responsive to the other. The court is the faithful agent or acts as a faithful agent, and it uses the canons to best construe statutes. Any interpretation Congress doesn't like can be overridden through new legislation. But the Facebook case shows that the court now deploys these canons virtually without regard to the will of Congress. So in the actual practice of the court, evidence of dialogue is increasingly thin. It's the really rare occasion that Congress acts to override or underwrite statutory interpretation decisions at the Supreme Court. And the decline in statutory overrides is all the more evident in this era of really rampant congressional gridlock. And the court's use of canons then features more inconsistency than not. There are dueling canons of at least two different types that at play that would confuse legislators, even were they to try to grasp the rules of the court or to defer. And then in the actual legislative drafting rooms in the halls of Congress, it turns out that Congress is neither aware of nor concerned with the canons that courts typically use. And that those who draft legislation sometimes explicitly reject the court's canons. So in a far-ranging empirical study of how Congress drafts statutes, Professors Abby Gluck and Lisa Bressman asked 137 congressional drafters whether Congress is aware of or accounts for the legal canons that courts use to interpret statutes. And the short answer was not really. They found that those who actually draft statutes are only aware of a subset of canons and that they explicitly reject some of the court's most favored and seemingly non-controversial canons, like some of the textual canons that we've been discussing, the rule against superfluities, the whole act rule, etc. So that disconnect is really problematic when it comes to justifying the continued use of canons on the court, which history says is not likely to subside. The court's current version of textualism, I think we're on textualism 3.0 or new textualism. It dispenses with the myth of court-Congress dialogue and hasn't even attempted to account for it. And the scholarly upset at the court at this development, or the pleas result in pleas for it simply to dispense with canons altogether, those seem doomed to failure. The court has always used legal canons to resolve cases and controversies. No one accepted that really minority proposal to just avoid interpretation altogether that we saw amongst the Muslim jurists once upon a time ago. My metacanonical inquiry seeks to shine light on the phenomenon and then to prompt finding ways of addressing it. How to do so with metacanons. I think there's a need to bridge the gap or this new divergence between continued new uses of canons using old justifications of court-Congress dialogue that no longer apply. And so rather than understanding canons as tools to facilitate court-Congress dialogue, I take this question that Professors Gluck and Bressman raised and sort of raise it comparatively. Might the canons instead best be understood to effectuate judicial responsibilities that are external to the legislative process, such as advancing constitutional values or legal coherence norms for furthering the rule of law? And so this is a challenge or provocation that I'd like to take up comparatively. Without dialogue, METACANONS reveals our system to look a lot like Islamic law, minus or without the new justifications or any guides for how to use the canons. And so I will conclude with a provocation that takes up that idea on metacanonical approaches. So comparative textualism helps reveal why and to what end courts today apply legal canons, despite the seeming improbability and difficulty of the comparison at first blush. A close look at each legal system shows that American and Islamic legal systems share many of the same legal canons, despite what perhaps are maximally different institutional structures, origins, and commitments, both historically and today. And moreover, there's little agreement in American law on when and why judges should deploy canons, and a flat out denial of the idea that their existence in Islamic law is even relevant in many circles. So my suggestion from the start was that probing each system individually, then juxtaposing the two, can reveal shared meta features of legal canons in these two very different systems. And the facts of their existence, their continued use, and the recent resurgence in both systems suggests that there are shared features of legal canons, these meta-canons that play out in every interpretation. I've highlighted a pair of them with the dueling last antecedent and series qualifier canons and the accompanying cases to illustrate the point. And now I want to end with a provocation on what to do with all of this. Identifying metacanons shows the possibility of legal historical comparison of two very different systems in ways that common comparative law methods don't account for. But it goes beyond that, and this comparative exercise may have payoff for thinking about American law once we cast it in relief to that other system. It seems to me that the fact of these similar legal canons in different legal systems, both of them lacking an institutional dialogue, call for some resolution on the American judiciary's use of legal canons in a system that has previously best justified its use of canons precisely on that notion of institutional dialogue. Moreover, there's historical and interpretive basis for that call. In American law, a historical review of statutory interpretation decisions show that founding era judges deployed canons with concern more for promoting coherence and rule of law principles than with congressional intent. And in Islamic law, parallel history shows that Muslim jurists have used legal canons since Islam's advent in the 7th century, sometimes drawing on the same Roman law maxims that Anglo-American common law judges adopted in the Latin through different routes. And juxtaposing the two, metacanons reveal some of the shared meta features between them. That is, if one were looking at text alone when determining which of two dueling canons to choose. But then that may be another fiction. Judges are never really looking at just the text alone. And if that's true, I argue that in our era of declining or perhaps fictitious institutional dialogue between courts and Congress, that means that legal canons in today's Supreme Court are once again interpretive tools solely for judicial interpreters, by judges, for judges, who now face a choice. They can, the same judges who have dispensed with the myth of dialogue should seek more coherent use of canons to bolster rule of law values of predictability and coherence. And identifying the universal features of metacanons can aid in that path. Or judges should reopen the channels of dialogue and deploy the canons to mediate the ongoing cases and controversies about changing values in light of congressional preferences and constitutional norms. This is a path that Islamic law judges did not and could not take, could not pursue, but thrown into relief by metacanons, this path offers a unique prospect, I submit, for advancing American democracy. Thank you very much.
Thank you so much, Professor Rabb. That was excellent. And we have a couple of questions in the Q&A for you. So we'll start off with this question from Andy Katz. Should we consider corpus linguistics an intrinsic source or an extrinsic source? It's interesting that Justice Alito was willing to go to a corpus linguistics analysis, but not to legislative history in line with strict textualism.
I think it's a great question, and thank you for the question. It's clear that it's an extrinsic source if we had to choose, right? It's not intrinsic because it's not intrinsic to an actual statute. No, it's not within the statutory text. And in the categories of canons that folks like William Eskridge or Justice Scalia and Brian Garner have delineated, there's a clear agreement on this idea that there are internal or intrinsic and extrinsic sources. So I too find that interesting that Justice Alito is willing to go beyond the text to an extrinsic source to shed light or meaning on the text. But I don't find it that surprising because I think it goes along with the idea of textualism, where the nexus between the text and what's now being called original public meaning as ordinary meaning of the type we saw in the Bostock majority calls on jurists to consult these external texts, dictionaries, and the corpus linguistics database would just be a stand-in for a dictionary. A dictionary is sort of a proxy for, this is what the word means at this time. Webster's Third was Justice Scalia's favorite dictionary because he thought the editors got it right as to what the popular norms are. And I think Justice Alito is saying, well, let's take that basic idea and add some more data to it. So agreed, it's interesting, it's extrinsic, but it's not surprising or inconsistent with textualism.
Thank you. Our next question is from Professor Katerina Linos. The comparison of maximally different systems is very useful to international law as we try to establish general principles of law shared among all legal systems. That list typically includes good faith, res judicata, contributory liability, and more, but I have not seen the two canons you mentioned initially, the rules of lenity and the ordinary meaning canon commonly listed. They would add a lot to international law and fill critical gaps. I therefore hesitate to ask, do they have counter canons, or are they not part of the dueling canon tradition? Are there other rules that are common to the Islamic and American tradition that don't have counter canons and are specific enough to do a lot of work in individual cases?
Thank you for the question, and apologies for my misbehaving camera. I think it's a really insightful question, Professor Linos, that, we don't always see these canons in international law context, and are there counter canons? I think that Carl Llewellyn's insight of long ago was basically correct, that for every canon, there's a counter canon, but I think he misapprehended the way, what that actually meant, or how canons typically are applied by judges in statutory interpretation cases. So one thing I wanted to, and so to back up, one more thing to say there is that that is to say that, you know, there are disagreements about these canons, but some of them become popular and they spread and they enter a legal system and gain authority over time through application, to the point that they become like memes, and you can sort of follow their spread and evolution and change over time and place. That said, you're always going to have dissenters, someone who doesn't love the meme or who disputes the premise on which it's based. So I think Llewellyn missed out on the idea that though there might be canons and counter canons, there's certainly more texture to that notion. There are majority canons, minority canons. I think I'm calling dueling canons the ones where we don't really know which ones are majoritarian and which ones are minoritarian, because we can detect courts using them in maybe equal measure, except we've never really reviewed them. When I reviewed the series qualifier canon against the last antecedent canon, it does turn out that the series qualifier canon is more popular across the history of some 33 cases where it appears in the American Supreme Court, but it was only named in Justice Scalia's book published in 2012. It kind of was used subsurosely. So therefore, I think there's a call then for some empirical descriptive study or appraisal, perhaps not in the way that Justice Alito mentioned about language in general in Shakespeare and other English literature, but I think the more appropriate corpus would be that of legal decisions in American law, legal decisions perhaps in these maximally different jurisdictions like Islamic law, and then with respect to international law, I think that could provide some basis as to which are majoritarian, minoritarian, have caveats, provisos, and exceptions that can at some point be ordered in a hierarchy, what applies when, and what might be attached to one jurisdiction over another, which is something I think we'll also find.
Whitney, sorry, you're muted.
Thank you. Sorry about that. A question from Najia Humayun. In Islamic law, as you mentioned, there are larger principles guiding which metacanon to apply, i.e. tending away from punishment/preference for forgiving the defendant. What should jurists in the US use to guide them, since there is not necessarily an applicable greater moral value code?
Great question. Thank you for it. I think there is. I think that, you know, it's a fallacy, I think, of Islamic law to suppose that it really is, there really is a code that is very clear, complete with the explicit spelled out moral value commitments that everyone should adopt. However, that said, I think that Muslim jurists have had a head start of some 1,200 years, so it's a 1,400-year-old legal tradition where 6 centuries in, five, 6 centuries in, they start trying to figure out what the weight of, where the weight of moral values falls in in an articulable way. And by that, I'm referring to their collections of these legal canons and attachment of them to overarching moral principles, objectives of the law, tendencies toward forgiveness and like. But the fact that there's something like an Islamic rule of lenity that spells out that principle, that is parallel to an American rule of lenity that spells out the same principle means that it's not that it doesn't exist. I think that more work needs to be done in identifying it based on the precedents that American lawyers through the common law and through legal canons elevate. We also, of course, have the Constitution, which is the font of agreed upon values, especially, well, not especially, I'd say both in the structure of the Constitution and in the rights amendments of the Constitution. And then finally, we have ways of articulating evolving values and preferences through representative democracy. And that's where I fall on the second suggestion. I think, fine, judges, you either go ahead with this idea that you're never going to talk to Congress and you delve into cleaning up these canons and finding the values there or coherence of practice there, or you open back up the channels of dialogue and you actually consult Congress for its preferences that are reflecting the greater democratic majority, and you apply the constitutional values that are right there and certainly within your role to apply, even if you don't decide to open up the channels of dialogue on structural grounds.
Thank you. It looks like we have a few more minutes left, so hopefully time for one more question. Okay, so does Islamic, this is a question from Professor Mark Gergen, does Islamic law have a movement similar to legal realism in the United States? A JSD student from a few years ago argued in his thesis that Jewish law had such a movement in the earliest 20th century, but rejected the stern secularism of legal realism.
There is, one of the great things about Islamic law is there's a great diversity of interpretations, and one of the features also of the varied Islamic societies is that there is no one Supreme Court or set of interpretive norms that are kind of a closed book. So I'd say that one can observe currents over time of changes and critique to the way Islamic law, to the way the leading authorities of Islamic law interpret it. And you can see expansion and contraction over time, more textualist approaches, more critical interpretive approaches that I think are always responsive to their time. So short answer, no, there wasn't a debate like there was, at Harvard and Yale and these other schools where the legal realists and the critics debated one another. But I think there are the seeds of the same and a diversity of interpretations that accommodates similar outcomes as the ones that we arrived at through legal realist debates.
Thank you so much. And I see it is 1:59, so I think we are out of time. Professor Rabb, thank you so much for joining us for this lecture. You were wonderful. I think I speak for the whole community when I say thank you so much. And I hope you'll be able to come visit us in person someday soon.
I hope so too. Thank you. Thank you all. And I look forward to talking to some of you more soon.
Thank you again. And a final thank you to Irving Tragen for sponsoring this wonderful series every year. We're so grateful to have him as an alum of Berkeley Law. Thank you, everybody. Have a wonderful day.